Hello, and welcome once again to the Disability Law Show. So glad you're here for the next 30 minutes. Stick around, got lots to teach you. John Scholes here. With me, James Fireman, Sivan Tumarkin, courtesy Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. Whether you're dealing with a disability insurer, they've decided not to even put you on claim, they've cut off your claim, or they've asked you to appeal, because that's always fun. Guarantee it's not, well, I can't guarantee, but it probably won't work. That'll probably come up sometime over the next half hour. Anytime during the show, after the show, you'll want to reach out to either of these two gentlemen. You can, 1-855-821-5900, help@disabilityrights.ca. And later on, our main topic is going to be 3 key questions about surveillance and LTD. Get to some emails and some other things. But guys, we always start the show, we get warmed up, as we say, with the week that was. Sivan, you got first crack, pal. What do we got?
Thanks, John. Great to be here with you and with James. Let me start off by telling you about a call that I got earlier this week from a lady just outside of Calgary. She's in her early 40s and she suffers from mental health issues. She's a marketing assistant. She has 2 small kids at home and she's struggling. She's been struggling all through COVID. That's exacerbated her condition. But, you know, she had issues even from before due to personal circumstances. Now, she went on short-term disability with the insurance company through the group health benefits plan that she has through work, and she was approved and she received it for several months. And when it came time to then apply for long-term disability benefits with the same insurance company, she was declined her long-term disability claim. And what's interesting is that when you look at the policy for the short-term disability and the long-term disability, the provisions, the qualifications for getting short-term disability and long-term disability are essentially identical. Now, her condition hasn't changed between the time when she was on short-term disability and when her application went through for long-term disability. So it begs the question, you know, why would the long-term disability insurer, which is the same insurer that paid her for short-term disability, decline her LTD claim? And when you look at the correspondence in the letters, you see that it's a different adjuster that is looking now at the long-term disability application. And so you have 2 separate adjusters who essentially are making 2 distinct decisions. One saying, yes, you have sufficient medical support through your family doctor, through the psychotherapist that's treating her, the psychologist, to approve her for short-term disability. And then one on the LTD side of things that says, no, you have insufficient medical documentation supporting your claim. Needless to say, I told you we can help you 100%. This is not going to be a difficult claim. In fact, it could be one of those claims where we can resolve it without starting the entire legal process. And that's something that I want to, draw our audience to, which is that, when you come to us, first of all, we know how to analyze the case. We understand very quickly what is going on when you show us the documentation. When we look at the policy, we look at the medical documentation, the denial letter, we can tell you on the phone within a matter of minutes whether or not the insurance company is correct in its denial of your claim or incorrect. Sometimes we need some more documentation, but generally it's very easy for us because we do this on a daily basis. And so when we tell individuals that they have a claim that the insurance company is incorrect, we know what we're talking about. And, so I explained to this lady what her options are. She spoke with her husband. She's going to proceed now with us. We're going to be able to deal with the insurance company. And I don't expect this to take a long time to resolve. I actually think that we can resolve this within a matter of weeks, maybe months at most. We move these things in our office very, very quickly, as fast as we can. We don't sit on these claims. I know there's other lawyers, unfortunately, that just, once you sign up with them, they'll put your file on a shelf and forget about it. We don't operate that way. Both James and I are very, very cognizant of, the pressure that people are under, the families are under. You got to put food on the table. You got to pay for bills. It's very, very tough. And so we move on these kinds of cases very quickly once we get retained to help people with these claims. So not a difficult case, but you can just sense the anxiety that this person was under, and you can understand really, that she was baffled, and she has every right to be baffled. How can the same insurance company approve and deny her on the same medical documentation? It makes no sense.
With the same test.
With the same test.
And actually, that's why I completely agree with you that this is a relatively easy case for us to pursue. There is a recent case out there that says very clearly, when the test remains the same, if an insurance company is changing your status from disabled to not disabled, they have the onus of proving why that has changed. And unless by some magical coincidence, this person's actual disability has changed on the date that the policy went from short-term to long-term, which, let's be honest, that's not what happened, then there's no way they're going to be able to justify it. It's why, actually, we see quite often what is much more common in this scenario, where you have the same insurer for short-term and long-term disability. What we do see quite often is just before the switch is made to long-term, like a week before you're supposed to transfer into the long-term disability, somehow they decide that you're no longer disabled. That we see quite frequently. It's still pretty obvious what's happening there, and that's certainly something that we can help with as well.
It seemed like the change of adjuster was part of the hiccup in this whole thing. Is that common, or is it usually the same adjuster, or two different adjusters is always the way it goes?
It really does depend. I can tell you a lot of times shortened disability is handled internally by an employer, so you do have a difference of opinion between what the employer is thinking, what an insurance company is thinking, but it really does depend on each and every case, which is why, by the way, we tell people, if you're denied long-term disability or you're cut off long-term disability, don't simply accept it. You need somebody that has the experience that does this on a daily basis to tell you if it really doesn't make any sense. And sometimes, by the way, even if the insurance company has some semi-legitimate reason for either denying a claim or stopping benefits, we can drill deeper, because sometimes there are other factors that may influence the decision as to whether or not the insurance company truly is in the right. So again, if you're denied, if you know somebody who's denied, and by the way, this advice is free, right? I just want to emphasize that. When we speak with people, that is free. It doesn't cost anything, not a penny to get this advice. So really, really important to understand that you need to call us as soon as this happens, or as soon as, that spidey sense is tingling. Even if you're talking to your adjuster and the adjuster is starting to ask you strange questions or want you to be seen by one of their doctors, something like that, you should reach out and get some more information from us. We can direct you and guide you.
The number again, 1-855-821-5900 anytime. There's also a website, pocketemploymentlawyer.ca. Usually we reserve that for the employment law show, but we talk about it here. Sivan, I know you love this particular part of that app that has to do with disability law, right?
I do. And John, just for any of our new viewers, Pocket Employment Lawyer was born out of an idea that some people just don't want to reach out to any lawyer, not just us, but just any lawyer. They're not comfortable, so they Google answers, right? The way you Google what to do if you have a cold or the flu or whatever. The problem is that when you just Google information, you may not get the correct answers. Oftentimes you go to websites from outside the country where the law is not even the same. And so we created the Pocket Employment Lawyer because we do a lot of employment law and disability law. And many people who have issues with their employers, with their employment, also have disability issues, disability questions with their long-term disability insurers, and vice versa. And so Pocket Employment Lawyer was born out of that. It's a free website. It's anonymous, quick, and easy to use. If you have any questions about your disability claim, you go on it, you input a few key pieces of information, and you'll get an answer that is custom tailored to your situation. And if you want to then reach out to us for a free in-depth consultation, by all means, you can do that.
Again, pocketemploymentlawyer.ca, real simple to use. Email address, we mentioned that off the top. We're going to get to one, help@disabilityrights.ca. Guys, first one for the show comes from Joanne. Joanne says, after a failed return to work from long-term disability, my benefits resumed through a recurrence claim, but only up until the 2-year mark. My doctors have indicated that I have a long road to recovery. What happens if I'm still not well enough to return after that 2-year mark?
This is a really good question that Joanne's asking here. So I want to just take a quick step back, though, and talk about recurrence claims, what those are, because it's important to understand. So when you bring an LTD claim and you're approved, a lot of times, most of the people that contact us, frankly, want to return to work. They genuinely desire to get better and go back to work. And so most LTD policies have what is called a recurrence claim. And what that means is that if you are on LTD, and you decide that you want to try going back to work, the policy will allow you to make an attempt to return to work. But if you are unable to continue working within a certain time frame, which is usually somewhere around 6 months, if you're unable to continue because of the same disability within 6 months, in other words, you have to go back on leave within those 6 months after starting, then the policy will re-engage. It'll be a recurrence, and you'll be entitled to receive benefits on an ongoing basis. The real key to that is when you apply for long-term disability benefits, there's usually a waiting period of 3, 4, 6 months.
Wow.
Before, oftentimes if you have short-term disability benefits, it's not such a big deal, but if you don't, then there's this period of time after you go on leave where you're not getting any long-term disability benefits. If you have a recurrence clause in your policy and it applies to you, it would help you to avoid that particular issue. So you would be able to try going back to work, and if you're not successful, in theory, be able to resume getting your benefits without having to go through that elimination period. So now let's apply that to Joanne's question. So what she's saying is that she, after going on leave, she was paid LTD benefits, she tried going back to work, and they allowed her to resume her benefits through the recurrence clause. Yep. But this is before the 2-year mark. And the 2-year mark is a critical point in long-term disability claims because the test changes. It changes from the own occupation test, whether your disability prevents you from doing your own occupation, to the any occupation test, whether your disability prevents you from doing any occupation you're qualified for by training, education, or experience. And so Joanne simply wants to know if she's back on claim because of the recurrence, is she entitled to get benefits beyond 2 years? I can tell you I've never seen a recurrence clause that would say that you're not entitled to after the change of definition, after those 2 years. But you do want to be aware of the timing because that can be counted in different ways. The typical way that it is accounted for is from the time you first go on leave, from the time you first start getting benefits, it's 2 years from then when the change of definition would occur, whether or not you went back to work for some period of time in between. So usually it's not going to bump back your change of definition date. You'll just want to be aware of that going forward.
What do you think, Sivan? Briefly.
No, I agree with everything that James said. I can tell you that, unfortunately, I've seen many cases where people have gone on to try to go back to work. And kudos to them, right? I mean, we want people to try and get back to work. We don't want people to stay on disability. And in that way, if you think about it, when a person does try to go back to work, for any number of reasons, the predominant one is because they're healthier and they think they can, their interests are aligned with the insurance company. So you think that the insurance company should be happy about that, and they are happy about that, but they're unhappy when that fails. They're unhappy when the person comes back and says, you know, that attempt has failed. I've gone to my doctor, and that's really important that you keep your doctor abreast of everything and that you're doing things in lockstep with your doctor's advice. And then you have a situation where a person tries to go back on claim through the recurrence clause, and the insurance company says no, for any number of reasons. Maybe you didn't try hard enough. Maybe we just don't think you're disabled anymore. I mean, they come up with all kinds of ludicrous reasons. And at that point, people are just surprised and shocked, and they're saying, but I did my best, I tried. And the doctor is writing, no, this person should be back on disability. And so we deal with those kinds of claims too. But I can tell you, people are absolutely shocked, and they feel like they have no options at that point, and that's not true. You absolutely do. If anything, I actually think that reinforces your claim. That makes your claim that much stronger because you tried to go back to work. So really understand that you do have rights. The insurance company cannot trample over those rights, and we can help you enforce those rights if the insurance company doesn't do what it's supposed to do by law.
Want to take a short break, guys? Stick with us when we come back. What you should know if you're being surveilled on LTD by your insurer. That's on the way. Short break, 1-855-821-5900, the number anytime, and help@disabilityrights.ca. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All righty, welcome back, Disability Law Show. So good to have you with us this week. John Scholes here, with me, James Fireman, Sivan Tumarkin. There's another website for you to check out anytime. Quick, easy to read, non-legalese notations, memos about LTD called LTDFAQ.ca. Use that, it's free and anonymous, of course. And email help@disabilityrights.ca. Want to talk about surveillance and being on LTD, but before we get into some questions and some points, James, just spitball surveillance. What's? I mean, we know what it is, but give me some brief strokes about it. What do you think?
Well, it's a topic that I'm asked about all the time because people have this fear that it's going to be something that is going to be automatic whenever they have an LTD case. And it is something that prevents a lot of people from even pursuing long-term disability benefits, just that fear. And it's actually quite an irrational fear when you really understand how it's used in practice. It's much more the exception than the rule. We rarely see surveillance on cases. It does come up, but it is unusual to see it. It is very unusual that it's actually effective. And the reality is, if you have a legitimate claim, if you are legitimately disabled, you're not able to work, and if you are being honest with your doctors and following your doctor's advice, if you are doing all of those things and all of that is true for you, then surveillance will not matter. It does not matter to you at all, because there is nothing that they can record you doing. There's no information that they can get that is going to contradict what is already in the medical records. And that is really the only purpose of surveillance, is to get you in a contradiction, is to catch you doing something that you say you can't do. As long as you are being forthright, then you got nothing to worry about at all.
Having said that, Sivan, is it legal for insurance companies to do surveillance on claimants?
Yes, it is, but there are limitations. They're not allowed to come into your home. They're not allowed to contact you to specifically, speak with you or be physical with you in any way. So there are limitations to that. John, I do want to add something to what James says. And both James and I had worked in our previous lives for insurance companies many, many years ago. And I remember my experience ordering surveillance on claimants when I was on the other side. And I agree with James. It's rarely effective. In fact, oftentimes, it's a double-edged sword, because once we have surveillance, sometimes it actually proves that the person is in fact disabled or injured, whatever the issue is. So insurance companies, I agree with James, they don't use it a lot. When they do it, sometimes it's to their own detriment. What I do find sometimes is that they try to gaslight you by saying that it says something that it really, doesn't show. The last thing I'll say is surveillance is very expensive. Insurance companies are inherently cheap.
No.
So for them, when I get a call and somebody says, listen, I've had this car outside my house for the last, 60 days, and I'm pretty sure it's the insurance company that hired an investigator 24 hours a day. No, I can tell you right, if that happened, within a week, the adjuster would be fired. It wouldn't happen. It's extremely expensive. And we've spoken with private investigators. We know some of these individuals. It's not what people think it is. It's rarely effective for insurance companies. And I agree with James, it's rarely a threat.
Well, you mentioned threat and your health and your privacy, James. If it's affecting your health or privacy in that way, can you ask the insurer not to conduct it? I mean, do you stand a chance of saying, please don't? Well,
so, in order for that to be something that you're actually doing, you would have to be aware
of it,
that the surveillance is there, which means that the investigator is probably not great at their job. Part of surveillance is to remain undiscovered.
Right.
And if someone is there watching you, that's obviously going to affect your behavior. So the investigators they hire are always going to do what they can to conceal the fact that they're there. So what do you do if you suspect that you are anyway, if maybe they're not doing such a great job? Well, the reality is that when they're conducting surveillance, they're not going to have a logo on the side that says private investigator or the name of your insurer. So you're not going to know that they are a private investigator who's following you around. You may have your suspicions and you may well be right, but you're not going to know. And that means that there is perhaps somebody out there that is following you for some other reason. Now, I'm not saying this to get anybody worried, but if you suspect that somebody is following you, even if it might be surveillance from the insurer, call the police.
Yeah.
Don't mess around with it. Because you're not going to know whether it's surveillance or not. And if it isn't, you want to make sure the police are involved. And even if it is, it's not a bad idea, because if you become aware of them, they are invading on your personal space. They're invading on your privacy. They have to remain completely out of the way. They cannot get involved. And if you're aware of them, they're not doing their job properly. The other side of this is, if you do become aware of somebody following you, you make the report to the police. I would also report it to your doctors. Make sure you're talking to your doctors or your therapists about someone following you, even if your suspicion it might be surveillance, but you don't know, and the impact that is having on you, if it is having an impact on you at all. For most people, it would be pretty disconcerting to realize that there's been somebody following you around and, you know, taping you while you're out and about and doing things that are meant to capture you in some way, that's going to be something that's going to affect people. And keep in mind that the people we're talking about are already disabled. Some of them are suffering from mental health issues. And if you're adding to that somebody following them around, what do you think that does to their mental health? So this can be an added issue, and if it's something that you've reported, not just to the police, but also to your therapist as an added issue, there could be damages the insurer has to pay for sending someone incompetent enough to be discovered that's actually making your situation worse. And I've had that happen, where it's created additional exposure, and the insurance company has wound up paying a lot more than they wanted to as a result.
Okay, Sivan, so we know it's not a common occurrence. It's rarer than most people think. It is expensive. It's costing the insurance company a lot of money. So does it often lead to benefits being cut off? Because they want to get something for their money, right?
Yes. The answer is it depends. Sometimes it does. I will tell you this. A more interesting question is not whether it leads to cutoffs, because it does sometimes. What's more interesting is whether or not when people come to us as a result of their benefits being cut off due to surveillance, whether or not we actually see anything on the surveillance that justifies the insurance company cutting off benefits. And I can tell you unequivocally that the answer is almost always no. It's not never, because things have happened in the past, but I can tell you almost always it's a no. And so for anyone out there who has been cut off benefits, actually for any reason, not just surveillance, they should consult with us. I remember a case a few years back where a gentleman contacted us. He was a fairly high earner, was making over $200,000 a year, and he had, I remember looking at the denial letter, and there were in excess of 10 reasons, including surveillance, by the way, as to why the insurance company thought he doesn't deserve any more benefits. We ended up going after the insurance company because he was able to explain each one of the things that they said was preventing them from paying him, or a reason for why they should not be paying him. And we're talking about a fairly significant six-figure settlement that was reached with the insurance company. And that's in a case where it's not just surveillance that led to the cutoff. There's one last point that I want to make here about surveillance, which is that when we talk about surveillance, we're talking about photography and video. That is actually not necessarily the number one problem nowadays. The number one problem, or what insurance companies often go for, is social media. People post all kinds of things on Facebook, Instagram, everything else. I'm not that savvy with social media. I know enough, though, I can tell you that
it's true.
It is true. I'm proud of that. But insurance companies will dig. They will dig. And you know, what do people put on social media? They want to put their best foot forward. So even if they're struggling, they want to put happy pictures. Nothing wrong with that, except that the insurance company is going to try and get to that and then create a narrative that you are much healthier than you appear. And from the insurance company's perspective, it's about perception, not about reality. And so keep in mind that surveillance is not always somebody outside standing with a camera. It's someone digging on the internet and Googling your name and seeing what comes up. So you have to be very careful. And again, the website that you had mentioned before, LTDFAQ.ca, contains a memo that deals with surveillance and deals with those kinds of issues and answers very basic questions. But of course, we're happy to speak with people about that. But it's common.
You know, when we started practicing, there was no such thing as social media. And I remember when it started to become more prevalent, you know, when people were on MySpace. And,
wow.
And we're going back ways. And I remember I would tell my clients back then, you know, just don't go on social media, shut it down. But that's not realistic anymore. Yeah. I know that. I could tell my clients not to go on social media, and they're not going to listen to me because it is such an integral part of people's lives now. But if you are bringing a long-term disability claim, if you're in the process at all, my strong recommendation is you pay a lot closer attention to the security settings on your social media.
Good call.
You be very conscious about what you are posting on there. Keep in mind that at the end of the day, there's at least a good chance that the insurers are going to get their hands on it. So think about it through that lens. I would put your security settings so that people who you haven't already approved aren't able to view your social media, and that people who people are not able to freely post on your, let's say, Facebook wall, because I'm old. They can't post on your Facebook wall without you having approved of it first.
Gotcha.
So just be mindful of those types of things if you are in the process.
Take a short break. Can other sources of income affect your LTD claim? We will tackle that when we come back. Lots more. The Disability Law Show is on the way. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show. Still a couple minutes to go here to reach out beyond this half hour. You can, no problem, 1-855-821-5900, help at disabilityrights.ca. There's also another website, mydisabilityquestions.com. Free and anonymous to ask your questions. You can even search it to see if a similar question has already been asked and answered by these two gentlemen or somebody at the firm. So let's go to that one, guys. Stephen, this time around, says, I've been on LTD for almost 3 years due to severe back pain and arthritis. After a close relative passed away, I was left some money as a beneficiary. Is this considered income that would affect my ongoing benefits?
No, it isn't. Inheritance is not income. It's just simply not. When you are receiving long-term disability benefits, you do have to be aware of how any money coming in is going to be treated by your insurer, but inheritance is certainly not that. There are other things, though, that you do have to think about, and so it's probably useful to talk about some of those. Passive income is something that people are concerned about. So if you have investments that are going up and you cash them in, do you have to pay for that? Almost certainly not. You want to take a look at the policy to be sure, but unless that is your main source of income, unless you are a day trader, for example, then having investments that gain you some income over the course of the year shouldn't have any impact on your disability benefits.
Severance?
Severance does. Well, most of the time it does.
Right.
You want to be very careful, take a look at your policy and make sure that they have an entitlement. But if your insurer has put that into the policy, that there is an offset for severance, then when you do get, if you are terminated from your position and you get paid, you're going to have to give some of that back, but not all of it.
Okay.
Not all of it. So typically speaking, when you're paid severance, you are paid the income that you would have over several months period. Let's say you're getting 8 months of severance. Well, that payment over those 8 months is going to be actually quite a bit more than you would be getting in disability benefits. Let's say you're getting $10,000 a month in income and $6,000 a month in LTD.
Got it.
That $80,000 over 8 months that you're getting isn't entirely an offset to your LTD benefits. It's 8 months. It's just the time period. It is not the actual full amount. That's a mistake that some people make, and sometimes insurers are more than happy to let you think that. So be careful that you're making that distinction. Sivan, you want to talk about some of the others? CPPD, for example?
CPP disability as well. Again, insurance companies are entitled to a credit for that. I think that the general message here is this. Oftentimes people contact us with these kinds of questions, and it is imperative that they do, because not all policies are the same. The wording can be different, and it's absolutely crucial for people to understand what the insurance company is doing. And if you have any questions and you don't want to contact us immediately, then ask the adjuster that's handling your claim, where in the policy does it allow them to get a credit or a claim a deduction, essentially, for the money that they are alleging that you just received. So if you have any questions, you contact us, but otherwise ask the adjuster to show you where it says that in the policy.
Because that's the Bible. It's got to be in the policy.
It's a contract, exactly.
It's got to be in there.
You got it.
Lots of good stuff today. Appreciate you reaching out, whether it was mydisabilityquestions.com, you had emails, all that stuff. You can also make the phone call. As we close off for another show, 1-855-821-5900. That email is help@disabilityrights.ca, and we just used mydisabilityquestions.com. There's one more. Remember this one, ltdfaq.ca. Quick, easy to read memos on LTD. You can use that any time. Thank you so much for watching. We'll catch you next time here on the Disability Law Show.